did a webinar a few months ago on the Colorado case, I call it, mainly because I found it fascinating. I thought really people need to understand what went on in Colorado and what gave rise to the case as it went to the Supreme Court. So I looked at this case having to do with immunity. The issue here is the president entitled to immunity from criminal prosecution for actions taken while he was president? And quite frankly, I didn't know the answer. I didn't know the law having to do with this subject. So I investigated it and thought it really was interesting. Now, there are certain precedents that are related to this issue, but not totally on point. There's a Nixon tapes decision you're probably aware of, that Nixon couldn't claim executive privilege to avoid a subpoena for his tape recordings when he was president. There was no executive privilege. Case of Trump versus Vance, which held that the president couldn't claim that he was somehow immune from state criminal subpoenas for documents. Trump had sued, claiming absolute immunity under Article 2 and the Supremacy Clause, but he was shut down and had to produce under the subpoenas. Nixon versus Fitzgerald, which I was not aware of this case when I first started looking at it. It held that the president is immune from civil suits based on his official acts as president. And in that case, the Supreme Court held that the alleged wrongful acts lay well within the outer perimeter of his authority as president. What happened in that case is a young Army, someone in the Air Force, was riffed, a reduction in force, and he complained that it was in retaliation for his testimony before Congress. So he sued a variety of officials, including the president. And the Supreme Court said no. The president shouldn't have to be worrying about the fact that he's going to be civilly liable for actions that he takes as president. So anything within the outer perimeter of his authority as president, he cannot be subjected to civil liability. Lastly, Clinton versus Paula Jones. You may recall that case. When the president is acting in a private capacity, and that was in a very private capacity, he's subject to civil suits. So we have those precedents, but we're wondering, okay, what's going to happen here with criminal cases and immunity from criminal prosecution? Now we go back to the Youngstown Sheet and Tube case, where in 1952, the president seized steel mills, and the court took the case and enjoined the president because it was not within his constitutional power to do this. So we have situations where the Supreme Court has said, President, you are not allowed, you are enjoined. Current controversy, I'm sure you're well aware, is the criminal prosecution in the District of Columbia, where the president was indicted, charging him with conspiracy to defraud the United States by overturning election results, conspiracy to obstruct an official proceeding, obstruction of an attempt to obstruct certification of electoral votes, and conspiracy against the rights of one or more persons to vote and to have their votes counted, all arising out of his lost bid for the second term, culminating in the rally, of course, on Capitol Hill, January 6th. So the case is in the district court in Columbia, in the District of Columbia, and it's held that the president has no immunity. It then goes to the DC Circuit, and the DC Circuit says absolutely no immunity from criminal prosecution. A very, very broad holding. They distinguish the situation from civil liability in Fitzgerald, holding that the public interest in criminal prosecution and the fealty to obedience to criminal laws outweighs any deterrence that it might have. The fear is it would deter the president from acting if he feared that he would be liable for criminal prosecution once he left office. And this does have to do with not a sitting president, but a president who has left office. The District of Columbia Circuit Court, which is the same as my court, we sit in the circuit, panel of 3 judges, said that in Fitzgerald, they were careful to say that their holdings regarding civil immunity and protection from civil damages did not carry over into the criminal realm. And also, it was distinguishable from Vance, where the president is under investigation, and also Clinton, where it was a very private matter. The District of Columbia Circuit Court, said that judges and Congress are not immune from criminal prosecution, and that the criminal accountability outweighs the risk of chilling the presidential action and vexatious litigation. And that is a real fear in the civil context. Anybody can bring a civil suit, and you are automatically a defendant. In the criminal context, there are certain protections against that, because the Department of Justice has to weigh in. You have to have an indictment. You have a grand jury has to indict. You have the protections afforded a defendant in a criminal trial. So there are differences. Another thing that they thought was important in the Circuit Court opinion in the District of Columbia was that Ford pardoned Nixon. Why do they need to pardon Nixon if there would be no criminal liability or criminal prosecution resulting from what had happened in Watergate? So these things swayed the District of Columbia Circuit Court to say absolutely no criminal liability. The other argument that was made in front of the Circuit Court was that there is an impeachment judgment clause that says judgment in cases of impeachment shall not extend further than to removal from office and disqualification to hold and enjoy any office of honor, etc. But the party convicted shall nevertheless be liable to subject to indictment, trial, judgment, and punishment. And the argument was made, well, of course you can't prosecute him unless he's been impeached. He's the president. This clause says impeachment has to go first. Only then can you be subject to criminal prosecution. But the District of Columbia Circuit Court said no. The intent there was to ensure that subsequent prosecution would not be barred. It wasn't to say that's a precondition to prosecution, but to say, oh, and by the way, even if he's impeached and convicted, there still can be criminal prosecution. So the District of Columbia Circuit Court said no immunity at all from criminal prosecution. So the case comes, well, it didn't come quickly, but, or maybe it did. Trump said, I need a stay. We need a stay of what's happened here in the Circuit Court because I don't want to be put to trial. And understandably, the Supreme Court took the case and heard argument on an expedited basis. So it goes to the Supreme Court, and the court stays the District of Columbia case while it decides the issue of immunity. And I must tell you that the minute you say immunity, it is immunity from prosecution. It is immunity from suit. So it prevents the prosecution from going forward. And in the federal system, when a police officer or other official is found not entitled to qualified immunity in the district court, you can take an immediate appeal to the Court of Appeals, because the theory is they shouldn't be subjected to that trial if indeed they are entitled to qualified immunity. So if the trial court has said you're not entitled, you can go to the circuit court. And if they reverse and say you are, then there is no trial. So the immunity concept is pretty important in our jurisprudence. So Trump argues before the Supreme Court that he has absolute immunity. He's betting the farm. I have absolutely no prosecution at all. I'm entitled to absolute immunity. The District of Columbia was totally wrong. It would undermine the president's ability to act without fear of later indictment. There's a lot of history, a lot of argument about Marjorie versus Madison in cases going up to Youngstown Tube. His view that under Marbury, there's just no way that the president should be subjected to criminal prosecution. And he relies on the impeachment judgment clause and says, listen, I wasn't impeached, I wasn't convicted. And it says, then you can have a prosecution. Without impeachment, you can't have a prosecution. So he's arguing that he's entitled entirely. And he says, Fitzgerald versus Nixon, really the same thing should apply here. There's a policy having to do with deterring the president from acting. He has to be free to act. And if he's afraid of criminal prosecution, it's not the way we want our government to work. And he's going to be besieged from baseless suits. He says, although there are protections in the criminal system, these there aren't absolute. We can have rogue prosecutors who decide to indict. And as we know, the grand jury hears from only one side. So the same considerations that prevailed in Fitzgerald prevail in the situation of the president and criminal liability. The government on the other side says there is absolutely no immunity. So we have black and white here. We have no middle ground. The framers, the president is not above the law. Again, a lot of focus on Marbury, on the cases. Everybody's reading these cases differently. And the government says, well, you have the prospect of impeachment. So when you're the president, you're not just going to act out because you could be impeached. So the deterrence effect of a criminal prosecution later isn't that much different from the deterrence of the impeachment that you could also happen. They also argue that Ford did pardon Nixon. And if there was no need to do that, if he could not be subjected to criminal prosecution, why was that necessary? And they distinguish Fitzgerald. The interest of enforcing the criminal laws is not the same as saving the president from a suit for private damages, as was the case in Fitzgerald. These are weighty considerations. We're talking about criminal laws. We're talking about the fact that no one is above the law. And that's what our country was founded on. We don't have monarchs and kings that are above the law. We have presidents. No one is above the law. Also, the safeguards, the government argued that there are these safeguards. They have the concept of the grand jury. They have the concept of the Department of Justice being impartial. They have the protections in a criminal trial that are much weightier and much more protective of defendants in criminal trials than in civil trials. So Fitzgerald really isn't something that is controlling here. And then, of course, the impeachment judgment clause. Impeachment, is a political remedy. The idea of that clause was just to make sure that everybody understood that there could still be a criminal prosecution. So, it really is a slam dunk as far as the government said. Of course, he has absolutely no immunity. So both sides are relying to a great extent on history, a lot of discussion of Marbury versus Madison. Few references to a very interesting case, which came down 3 months before the DC Circuit case, the DC Circuit case from which this appeal is taken. And that case is called Blasingame. That had to do with, again, civil liability. Capitol police officers and members of Congress sued for civil damages arising out of January 6th. They sued specific people, a lot of different people. There were a lot of cases, but the only defendant named in all these cases that was common was Donald J. Trump. And the district court rejected the concept of, the district court in the Blasingame case had rejected the concept of immunity and said the president is not immune because these were private acts. So we had in Fitzgerald the concept that the president, as long as it's within the outer perimeter of his authority, we look at the president, we say, what's the perimeter of his authority? The outer perimeter of his authority, that there it was easy. It had to do with an Air Force reduction in force, certainly within his authority. But they created this concept of the outer perimeter of his authority. So the district court in Blasingame said all outside the outer perimeter. So the DC Circuit looked at it a little differently. Again, bear in mind, this is civil. This is like Fitzgerald. It isn't criminal. So the DC Circuit talked about the difference between matters that are official acts and private acts. And they noted that when the president intervened in the election cases that went around the country, he made a point that he was intervening in his personal capacity as a candidate. And if he's arguing in his personal capacity, isn't that outside the outer perimeter? The DC Circuit posed more questions than it answered. But it set forth a lot of different thoughts as to how we should look at this. Now, Trump had urged that when he spoke on a matter of public concern, it was necessarily official. Necessarily official. And the court in Blasingame said, well, that is too broad, because presidents always speak on a matter that concerns the public, whether it's right or wrong, it concerns the public. And they talked about the outer perimeter, and they said it has to bear a connection with general matters committed by law to his control or supervision. When is it in the private capacity? When is it official? They said it's an objective inquiry. It's context specific. It has to do with an assessment of the nature of the function performed. Is he acting officially? Is he acting as a candidate, as a seeker of the next election, or as a president? But they didn't decide the issue. They said immunity from suit needs discovery bearing on the issue. And the case had come immediately to them, just on the pleadings, and that's not enough. So the District of Columbia Court of Appeals said he will have the burden to show he was exercising his official responsibilities as president. If he can do that, so be it. He will be immune. If not, he will not be immune. So they sent it back to the district court to make this decision. And this is in a civil context. It's just one removed from Nixon because it's a closer case, because that outer perimeter test is being tested. Where was it in terms of the outer perimeter? Was it beyond? So it comes to the Supreme Court. Nobody is citing Blasingame because it's a civil context. It's Nixon versus Fitzgerald. It has nothing to do with the criminal context. They come to the Supreme Court and they're arguing it's a fight about Marbury versus Madison and what they said in Marbury and what it meant with respect to the discretionary acts or the ministerial acts of the president. You assume that the impeachment judgment clause is going to feature big in this argument. What does it mean? Did the framers mean that conviction and of impeachment is the only way that you can have a criminal prosecution? And we've got to talk about the policy of the president being able to act without fear of prosecution. These things are going to be important, and each side framed the case all or nothing. Trump says total immunity, and the government says no immunity. So we come to the Supreme Court, and we have oral argument. So right off the bat, Justice Thomas, Clarence Thomas, how do we determine what an official act is? Wait a minute. We're really not talking. I mean, that's Blasingame. That's something else. We're really not parsing this official act stuff. This isn't what we're arguing. We're arguing history. We're arguing all these other things. The attorney for Trump embraces the outer perimeter test from Fitzgerald, and from Blasingame, he doesn't say, but wait a minute, there's the impeachment judgment clause. He doesn't urge policy. Justice Gorsuch talks about Blasingame. And Sauer says, yeah, anything that's plausibly connected to official duties is official. He's embracing this test that is, it's basically a trap for Trump, but he's falling into the trap. Kavanaugh, where did the District Circuit Court go wrong in Blasingame with the official versus personal dichotomy? Trump's lawyer says, we agree with most of what the opinion said. Clarence Thomas says, is it when he's acting as a president or as a candidate? And Trump's lawyer says, we don't really dispute that. We have Amy Coney Barrett posing 3 hypotheticals to Trump's lawyer. Okay, petitioner was willing to spread knowingly false claims of election fraud to spearhead his challenges to the election results. Private? Mr. Sauer, Trump's lawyer. That sounds private to me. Amy Coney Barrett. Petitioner conspired with another private attorney who caused the filing in court of a verification signed by petitioner that contained false allegations. Private? That also sounds private. And yet another hypothetical. Well, okay, that sounds private. He's kind of falling into a bit of a trap, going off on the official versus private test instead of pushing impeachment judgment, instead of pushing Marbury versus Madison, instead of pushing policy. So then we have Justice Alito coming to his rescue and says, well, isn't the president in a special position? You know, he's in a special position, right? And I really dispute that there are really layers of protection against criminal prosecution. I mean, everybody knows that a grand jury could well indict a ham sandwich, which gets a lot of laughs. But, you know, they say that because in front of the grand jury, it's only the prosecutor. So the prosecutor puts the evidence on. So Alito is saying, you know, is it really fair? Are there really the protections that should distinguish it from the civil case? And don't we have policy reasons that the president is special? No other justice picks up on this. The Chief Justice pays a little lip service, but hardly any. The government attorney knows he has their attention, but he seeks to limit the official concept to the core powers, statutes that actually give the president power. He tries to narrow the official, because as soon as he narrows the official, the outer perimeters of official are pretty narrow. And he wants to argue that it's a public authority defense. In other words, the president can urge as a defense that he was acting pursuant to his public authority. Why would he do that? Because he wants the case to go to trial and have the president have to assert a defense. He doesn't want immunity, because immunity means no trial. So he's urging that this case can go forward. There are sufficient private acts to proceed with the case with jury instructions. And during the argument, Justice Sotomayor said the same thing. Well, actually, you could proceed with, there's so much of this that appears private, and yet what may be official provides context. So you let the jury hear it, but then instruct them as to what part is, when it's private, that's what they can convict on, but not when it is official, if you will. So the argument kind of devolves into the next step. And it's interesting that in the government's brief to the Supreme Court, it's a 49-page brief to the Supreme Court. At page 46, the government says, even if the court were inclined to recognize some immunity, it should remand for trial because the indictment alleges substantial private conduct. The district court can make evidentiary rulings and craft appropriate jury instructions, blah, blah, blah. So the fight really comes down, they've kind of given in, kind of thrown in the towel, if you will, on the arguments they came to make, because they saw the handwriting on the wall with Clarence Thomas's first question. So where they came arguing total immunity, no immunity, they soon see that there's going to be some play here. And it's probably going to come down to what's official, what's private, what's a candidate seeking re-election, what's a president. And they try to argue to what the next step should be. Remand for trial and sort it out through jury instructions, and the judge can instruct the jury, and that works fine. Or immunity from suit, which means you got to figure out ahead of time and only go forward on those things as to which he is not immune. Really interesting, the transcript of oral argument. At the end of the transcript, there is a huge directory showing you where certain words are used during the argument. And I love this. The word Marbury was used 7 times, Marbury versus Madison. History, they're all arguing about history. They come to the Supreme Court. It's argued 7 times. 5 of them by Trump's counsel, 1 by the government counsel referring to Trump's counsel argument, and 1 by Justice Kavanaugh saying it stands for the proposition that you can't enjoin the president. 7 times. In the briefing, it's everywhere. Impeachment judgment clause mentioned 3 times, 2 times by Trump's lawyer. He gave up the ghost on the impeachment judgment clause. The word official appears, I couldn't count the number of times, I just counted the pages, 72 pages, obviously talking about official versus private. The word private on 36 pages, and Blasingame on 12 pages. So the interesting thing here is how this has morphed from what the parties wanted it to be about and what it actually came to be about. It came to be about a case called Blasingame, and Blasingame was mentioned in the briefs, but a citation, just a cite, like a page cite, 2 or 3 times, because it was a civil case. It was just the next iteration of, the Fitzgerald case. It's a civil case. What does that have to do with anything? But the Supreme Court has to decide cases, and they have to figure out how. And to my mind, they realized that this is not an all or nothing. This is not an all or nothing situation. We're not going to find that he's totally immune. I mean, criminal laws mean something, and the president is not above the law. And they're not going to find that he has, no immunity. So, they're not going to do this all or nothing. And it started out, and all of a sudden, Blasingame became the be all and the end all. And once Sauer conceded Blasingame as a test, I think it was off to the races. He could have said, well, that's in the civil context. We really have no official private here. We have no history of an official versus a private, because, as you know, the Supreme Court recently has been talking all about history. And that's why I think the briefing to the Supreme Court was all about history. Each side's view of Marbury versus Madison and Youngstown and all the cases in between. I mean, the briefing had all these cases and what they meant for the discretionary acts. But the Supreme Court, all of a sudden, didn't hew to the idea of history. They realized they had to find a way. And they said during the argument, this is not about this case. Just kind of like the Colorado case. This isn't about this case. This is about setting a tone for the ages, for, courts to come. We've got to say what the deal is, so everybody knows what the deal is. We can't say there's none, and we can't say there's total. It doesn't work. And once counsel could buy into the Blasingame framework, as I said, they were off to the races. But it was interesting to me that in the immediate wake of the argument, no one picked up on the back and forth with Justice Barrett. It took about 2 weeks. Now, and I may be wrong, maybe Bruce, maybe you saw it in the news, but it took about 2 weeks for me to see something called concession in oral argument. And they talked about this aspect. But it was kind of striking that he said, private. It didn't even try to argue that, well, but once you look at some more things, you've got this outer perimeter, and if it's an outer perimeter, it's not a tight little perimeter like the government wants. The government wants it to be core powers, but no, the president has lots of authority. He's the commander in chief. He's all these things. He really has to concern himself with everything. But Trump's lawyer, I don't think did him much of a favor in terms of bringing the justices back to the impeachment judgment clause, bringing them back to history, bringing them back to the policy, I mean, Alito kind of stood alone by saying, well, the president's different. You know, I do think that once you say the president can be subject to impeachment, the argument that later criminal prosecution is going to be a deterrence, impeachment should be a sufficient deterrent that he's not going to go off the deep end, let alone criminal prosecution. So that's my take on this case. The court will be issuing its opinion in the next 18 days, and we'll see what it says. I believe they will send it back, and I believe there will have to be discovery about and consideration of what is private and what is official. And guess what? Because it's immunity, after the district court decides that what's official, what's private, to the extent that they deny immunity with respect to certain acts, that will have to go up again on appeal, because when it's immunity, you will have an appeal. So we have a bouncing ball. I predict there is going to be no quick trial in this case. And in fact, not only is it going to go down to the district court for them to determine, but then there's going to be that immediate appeal. And we are a long ways away from resolution. And it could be that Trump's lawyers, buying into the Blasingame approach, thought, hey, listen, we'll drop back and punt on this Blasingame and just take our chances to keep the bouncing ball, go back to the district court, go to the Court of Appeals, it's immunity, blah, blah, blah. It'll be such a long time, it won't even matter. He will not be in a courtroom in the District Court of Columbia for quite a long time, because this has to go bouncing back and forth. I think that's where it's headed. So that's my 2 cents, 5 cents, 10 cents.